So we're here to talk about Title IX, but taking a step back, we've done a lot of work for higher ed institutions. Maybe you can describe a little bit generally what the nature of that work has been.
Sure. We represent colleges and universities in a broad range of educational issues, including Title IX, also Department of Education compliance issues, things as diverse as student conduct, somewhat related to Title IX, and of course, certainly over the last half dozen years or so, lots of Title IX activity.
There's been a lot of work around employment law and general contracts and those type of things as well.
Absolutely, and also leasing, real estate, some issues with state and local tax, among other things.
I know privacy issues come up and student conduct and those type of things as well.
Lots of things. Study abroad, even some accreditation issues and academic requirements, faculty tenure issues, both faculty handbooks, student handbooks, employee handbooks. We have also jumped into some labor relations issues relating to faculty and university.
So the university context involves a lot of complexity and a lot of legal issues, but in particular, over the last 10 or 15 years, Title IX has been a pretty rich arena of litigation and risk exposure, and you've done a lot of work around Title IX, right?
Title IX feels like it's been as sort of at the forefront of a lot of discussions, both at the college and university setting, and also in society more generally, because the real issue in Title IX is this, the phrase, on the basis of sex.
So there's been a lot of work and a lot of litigation and risk exposure around Title IX. As a starting point, what is Title IX?
Title IX is a federal law that prohibits colleges and universities from discriminating on the basis of sex in their educational programs and activities. Back in 2011, under the Obama administration, the Department of Education put out what is called a Dear Colleague letter, which is essentially guidance, not formal regulations, but guidance to colleges and universities that essentially told them you have to step up your oversight of discrimination on the basis of sex, or you risk oversight by the Department of Education.
So what was the way that they were requiring increased oversight?
Well, increased oversight was that the colleges and universities were required to take seriously a broader range of sex-based discrimination, including sexual harassment, in their programs and activities. And that includes student-on-student sexual misconduct, student and employee sexual misconduct. And so all of a sudden, this had become a big issue for colleges and universities. And the Obama administration backed that up. They were viewed as really aggressive in terms of going after colleges and universities they didn't deem were taking sexual misconduct seriously enough.
So then the colleges and universities in turn stepped up their enforcement efforts, and we saw a lot of litigation and a lot of claims and processes and procedures around those claims.
Yeah, lots of procedures, both at the intake level and then at the investigation level, including for hearings. And they were very extensive and I think viewed by some as having gone too far in protecting victims of sexual misconduct at the expense of those accused of sexual misconduct. And so there had been some discussion as to whether there should be more due process protections put in place to protect those accused of sexual harassment. But that didn't really happen in the Obama administration. And so things sort of ended up that colleges and universities found themselves in many instances at odds with and under investigation by the Department of Education.